Hello everyone. Today I would like to discuss a particular regulation in the European Union law. It is about Regulation 2016/679, which regulates the privacy issues between private parties. What I notice is that companies find it mostly difficult to assess whether or not they act in compliance with the European Union privacy rules. Therefore, I came up with a four-step approach to check whether or not your organization acts in compliance with this regulation. Step 1. Is this regulation applicable in the first place? Obviously, not all data processing is subject to this regulation. It only concerns data that could lead to the identification of a person. This could be direct identification, because, for instance, you process someone's name or address. Could also be indirect identification. For instance, you have several sources that are about a certain person, and when you combine those sources, it will lead to the identification of that person. For instance, someone's zip code, age, gender, and profession. When you conclude that you indeed have to act in compliance with this regulation, we go to step 2. Step 2 is actually Article 5 of the regulation, and in this article you will find the most important principles you have to stick to when you process someone's data. The first principle can be classified as lawfulness, fairness, and transparency. Of course, you have to act in compliance with the applicable legislation, so data processing should never lead to the violation of the law. Then, of course, you should be fair in your data processing, so you should not mislead someone when you process someone's data. And the data processing should be transparent, meaning that when the data subject wants to know what kind of information you possess about this person, you should be able to give it and to show what you're actually doing with that data. Purpose limitation is the second principle, and this means that you define the purpose for which you actually process the data, and you communicate that to the data subject. The third principle is data minimization. It means that when possible, you should not exceed the amount of data that is required to realize your legitimate interest. So you should not process more data than is necessary to realize the purpose you just set. A fourth principle is accuracy. This means that the data you do process should be accurate. In other words, it should be correct. The fifth principle is storage limitation. You cannot forever keep the data you process. There are limits to that. The last principle is integrity and confidentiality. This basically means that you should protect the data you process and make sure that you do not leak this data to somewhere else where it can be used for ill purposes. Well, let's go to step 3. When you conclude that you stick to all these principles, you're doing a fair job. However, next to that, you always need to be able to invoke a justificational ground that can be found in Article 6 of this regulation. If you cannot invoke such a justification, the data processing will be illegal. There are several grounds on which you can justify data processing. The first is the most obvious one. When the data subject gives its consent to a particular data processing, it usually is just fine. The second one relates to contractual agreements. If it is necessary to process someone's data in the performance of your obligations in a contract, you can basically do that. So, for instance, when a consumer orders something online, of course you will have to use its name, address, and so on, because you have to send the package to its home address. The third justificational ground is when you have to comply with a legal obligation in processing someone's data. The fourth is when you have to act in the vital interest of the data subject and as a result of that process someone's data. For instance, someone's blood group, when someone is about to die, you will probably try to recover that particular data to protect the vital interest of the data subject. Another justificational ground is when you perform a public job, and in that performance, in that capacity, you have to process someone's data. In some countries, when you check someone's car every year, you have to give that information about that check also to the government or to the governmental institutions. In that sense, you are not only acting as a company, but you're also acting in your capacity as a public legal organ, and therefore you can process this data. The last category is some sort of an etc. Category. In essence, it comes down to this. You balance the interest of the company against the interest of the data subject. When the interest of the company is more important, of a heavier weight, so to say, than the interest of the data subject, the company will prevail. For instance, when you have bought something at a certain company and you've left behind your email address, it's only a matter of logics that this company will use that email address to send you another offer within a couple of months' time, or to send you some commercial advertisements and so on. In essence, usually we say that it's in the best interest of the company to be able to do so. I mean, if they cannot advertise, they cannot sell anything, and there is no real violation of the privacy of the data subject. However, it is a case-to-case matter whether or not the interest of the company will prevail in this last justificational ground. If you can invoke one of the justificational grounds that are listed in Article 6, you are almost done. There are certain types of data we rather not process because they are so private that a company or any other private organization has nothing to do with that. Think about your sexual orientation, your political flavor, your health, and those type of things. They are often considered to be of such a private nature that in a normal setting we do not process such data. If you still want to process those type of data, you have to look into Article 9, because there is a particular heavier regime under which you might, under certain very limited circumstances, still process this type of data. Now, last but not least, I think it's a good idea to point out that there are certain rights for the data subject. For instance, the data subject has a right to ratification when data proves to be inadequate. Another thing is the so-called right to be forgotten. If a data subject doesn't want certain data about her or him to be well known, you can ask this company to remove the data and, in that sense, be forgotten. There's also the opportunity for the data subject to restrict the data processing, especially when data processing is inaccurate, unlawful, or disproportionate towards a legitimate goal. Next to that, sometimes the data subject would like to receive the data you are processing, and the data subject actually has a right to receive that information. Last but not least, you can simply object to any data processing, especially when it is in the context of direct marketing activities, hence the unsubscribe button in mailing lists from companies. Well, after seeing this video, I hope you learned a little bit more about privacy law in the European Union when it relates to private relations. We've discussed 4 steps and some rights of the data subject. For more information, you might have a look at www.drwernert.com or like Dr. Wernert at Facebook. Thank you very much for watching.